Welcome to Southeast Asia IP SME Helpdesk, your gateway to expert advice on intellectual property in Southeast Asia. In this video, we'll take you through the core services we offer to small and medium enterprises across Europe. Let's dive in and discover how we can support your business. We are an initiative of the European Commission providing free and confidential business-focused advice to European SMEs. Our mission is to guide you through the complexities of IP in Southeast Asia and help you safeguard your innovations and creations. Our help desk offers a comprehensive suite of services tailored to meet the unique needs of European SMEs. Enquiry Helpline. Have an IP question related to Southeast Asia? Reach out to our Enquiry Helpline and receive expert advice within 3 working days. Or book a one-to-one meeting directly with our IP business advisor via this link right here. Training and webinars. Join one of our training sessions or webinars designed specifically for European SMEs across Europe and Southeast Asia throughout the year. Stay updated on upcoming activities by subscribing to our newsletter and connecting with us on social media. Publications. Access a treasure trove of resources on our website, including country fact sheets, industry-specific IP guides, and general IP guides covering a variety of topics. Dive into our publications to enhance your understanding of IP laws and practices. Access a wide range of resources anytime, anywhere. IP business tools. Explore our IP cost and diagnostic tools, accessible on our official website. These tools are crafted to empower you with the knowledge you need to navigate the IP landscape effectively. The Southeast Asia IP SME Helpdesk is your reliable partner and go-to resource for navigating the IP landscape in Southeast Asia. With a range of services at your disposal, we are committed to helping European SMEs protect their innovations and creations and succeed in the global market. Contact us today to take the first step towards securing your IP assets and unlocking new growth opportunities.
Hello everyone, and a very warm welcome to the webinar Brand Protection in Laos. My name is Stefano Pighin. I am the Executive Director of the European Chamber of Commerce here in Vientiane, Laos. And I am thrilled to have you all joining us today. Today's session is brought to you in partnership with the Southeast Asia Intellectual Property SME Helpdesk. Before we dive into the main topic, I would like to briefly introduce EuroCham Laos. We are the official representative of the European business community and the largest international chamber of commerce in Laos PDR. As of today, we represent 120 companies, half of them are SMEs, through our active engagement with the Lao government, networking events, and tailor-made services. We provide practical support to companies navigating the Lao market, whether they are in the initial planning stages or require support for existing operations in the country. And now just a few housekeeping notes to ensure a smooth experience for everyone. We encourage your questions, so please submit them at any time using the Q&A section. We will dedicate time at the end of the presentation to address as many as we can. This webinar is being recorded, and we will be sharing with you after the event. If you encounter any technical issues, please let us know via the chat. All right, now it's my pleasure to introduce our speaker, Mr. Dino Santaniello. Dino is an international consultant with a broad experience in various areas of Lao law, including trademarks, privacy, data protection, corporate establishment, and other commercial transactions. And we are incredibly lucky to have him with us today. Over to you, Dino.
Thank you very much, Stefano. And good morning to everybody, and thank you for attending this webinar. So I will try to share my slides, Stefano, so just let me know if that works.
Mm-hmm. Okay.
Do you see something?
Yes.
Okay, fine. So my name is Dino, and today's presentation will be broken down into 6 different parts, actually. So first of all, we'll be speaking about the legal landscape of the country, speaking of the main regulations, domestic regulation and international legal instruments. Thereafter, we'll be discussing the key recent developments. Moving on, we'll be having a talk on parallel import in the country, because I know this is something of concern for many businesses in the country also as well. And then we'll have a discussion over trademark with a focus on registration and some recommendation for brand protection. And the presentation will end up with patent and industrial design, where I will be only providing basic information in relation to the registration of those intellectual property. So at the end of the webinar, there will be also a Q&A session, so feel free to ask any questions that you may have. Without further ado, let's move on to the legal landscape. Here it is. So hopefully you can see the screen I have in front of me also as well. So there is a table where you can see actually the main domestic regulations. Without surprise, the main piece of legislation is actually the Law on Intellectual Property of 2023. So 2023 relates to the dates at which the law was actually approved by the National Assembly. But the law was published in 2024, in March 2024, and then was enforceable since the end of March 2024. So in any event, that's a very recent regulation. The law provides a lot of general information in relation to definitions of intellectual property that is protected, the scope of protection. However, the law is maybe too general, and this is why we do have lots of subsequent regulations that you can see on your screen also as well, on patent, industrial design, and trademark, for instance. So those regulations are very important to refer to if we want to make sure that we provide a full advice on each type of intellectual property. At the very bottom of the table, you can see 2 types of regulations about dispute resolution and IP, about IP service provider. So it provides clarification on whether there is a dispute in relation to intellectual property, whether it concerns a cancellation on opposition to a registration of a trademark, for instance. So all the procedures are set out actually in this regulation on dispute resolution. And the last piece of regulation is about actually the criteria and requirements to become a IP service provider duly authorized by the Department of Intellectual Property. On the left side of the slide, you can see 2 logos. Important one, because here we are talking about the supervising authorities of intellectual property in Laos. So on the top of it, we have the MOIC, the Ministry of Industry and Commerce, which supervises the work of the Department of Intellectual Property, DIP. So the DIP is responsible to provide advice, recommendation on any type of amendment of regulation, new regulations, but also in charge of all the registration of intellectual property in the country. It can also assist in the enforcement of those rights. Then I thought it was also worthy to mention 2 other types of regulations from the Ministry of Finance, at least drafted with the help of the Ministry of Finance and particularly the Customs Department. It is a law on customs, because customs officers do also have some right and duty in relation to the protection of intellectual property. And then you have also the instruction and measures of customs officer to protect intellectual property rights. So this provides for the first time to Laos a mechanism of what we call customs recordal. So intellectual property rights holder can actually register their intellectual property with like a trademark or patent for an invention or an industrial design. They can register it with the Customs Department, so that the customs officer can have a particular look in order to make sure that there is no shipment containing infringing goods. Moving on, here are the main international legal instruments. So it's not all the international agreements, but most of them, and the main one, at least for me. So this is interesting because in the first place, we may think Laos as an isolated country. It's a landlocked country, so that's a fact. However, Laos is also very active on the international stage. And as you can see, Laos is a member of many international agreements. I would just maybe mention two, the TRIPS agreements, for instance, and which Laos is a party of. And this is why actually Laos is capable, on the paper at least, to provide the same type of standard in relation to intellectual property protection, same as countries like France, for instance, or Italy or Japan, because they are part of the same agreement, providing minimum standard of protection. And you may also have heard about the Madrid Protocol. You can see also on your screen of which Laos ratified in 2015 or joined in 2015. And it allows you to actually register your trademark by filing just one application. So then you can see also bilateral agreements. Here I listed a couple of those. In relation to patent, Laos has signed bilateral agreements with Japan, South Korea, Singapore, even China actually. But we can see lastly what with the European Patent Organization in 2024. So that allows patent rights holder, those who have registered an invention in their country of origin, that as soon as they did register their invention, they are being granted with a patent, they can take it and submit it to the Laos IP office to proceed with the registration. And it provides a fast-track system to register those patents in a way faster manner than it would be if it was not registered prior hand. So now, here was just a brief overview of the regulations. Now we will be discussing on the key recent developments. So, first of all, it's not very, very new, but I wanted to mention the e-filing system. I think now it's since November 2023 that Laos has launched their online platform to actually receive application for trademark registration only so far, in order to be able to file and register a trademark via the online platform of the DIP. That's a huge step forward for Laos. The DIP has been working on it for some time, and it shows the commitments of the Department of Intellectual Property to actually provide better and better services to IP professionals. Because so far, this system is just open to IP professionals, meaning that people like you or me, or any other people actually who are not authorized to work as an IP service provider cannot use this website to file their trademark. So it would be still necessary to actually go to the Department of Intellectual Property or the Department of Industry and Commerce to proceed with the registration paper-based. Also, I wanted to emphasize on the fact that the e-filing system changes nothing for foreign-based applicants. For instance, for a European-based applicant who would like to register their trademark in Laos, they still would need to go through a local and duly authorized IP professional, unless you use a Madrid Protocol registration system. However, today I would like to be transparent. I will not be speaking about the specific of the Madrid Protocol registration procedure. That may be the subject of another webinar in the future. But even though we are not using, we are using actually the Madrid Protocol registration procedure, at the end of the day, the application will be received by the Laos Department of Intellectual Property, which will be reviewing the application under the Lao law perspective. So everything that will be spoken today in this webinar will be very helpful, either you use the Madrid Protocol registration system or not. Now, specifically on the change that were made by the amended law on intellectual property of 2023. One change to notice in the first place is about well-known mark. So what is a well-known mark? So that is a mark that is so popular that does not require registration in order to obtain protection under the law on intellectual property. Let's assume for an instance that Coca-Cola has no registered trademark in the country. It is most likely that Coca-Cola will also be qualified as a well-known mark and therefore will also benefit of protection, even though Coca-Cola did not register the trade name Coca-Cola or even their very famous logo, because it's so well known. So they receive protection even though they are not registered. They did not register the trademark. For your information, there is no list of well-known marks. So there are a list of criteria that actually the DIP will be assessing, considering to qualify a mark as a well-known mark or not. So essentially, the amendment is about those criteria actually, and specifically 3 of them. So in green, you can see the addition of the law on intellectual property of 2023, and in red, what was deleted. So one of the key criteria actually now to determine whether a mark is a well-known mark or not is whether or not the mark is recognized according to the marketing, the promotion of the mark within Laos. So when we talk about the promotion here, there will be the advertising, all the marketing made within the country. While before, one of the key criteria was that the mark is recognized by the relevant industry within the territory of Laos. So by the relevant industry, I think it was very difficult to understand exactly what that means and how to bring the evidence. Do we need to question any stakeholders from the relevant industry, whatever that means? So I think now the new drafting, the revision is clearer, has clarified actually the criteria of well-knownness, if I may, because it's easier to gather evidence that there is a lot of marketing in the country surrounding a specific mark. One of the criteria also that was modified is that before there was also a need to bring evidence that the goods, the product and the goods bearing the trademark was widely circulated in the country. Now the new amended law actually deleted the term within the territory. So we can assume that the DIP may also take into consideration the fact that the product bearing the trademark are circulated widely worldwide. We do not need specifically maybe to bring the evidence that those goods are circulated within Laos specifically. And the last amendment related to well-known marks is about the fact that now we do not need to have any type of certification from consumers saying that they do recognize the reputation of the trademark. The law now just say consumer widely recognize the reputation of the trademark. So that's, again, I think clarifies the type of evidence that can be brought, because what means that the consumer certify, just recognizing would be enough. An evidence that could be brought in that case, for instance, it would be a poll survey. A trademark owner could be undertaking a survey within Laos to demonstrate or evidence that the Lao people knows the mark, for instance. Moving on, a very important, I think, change in the law, in the revised Article 19, is about the mandatory registration of trade names if you want the trade name to be protected. So a trade name is the name of an enterprise, basically. Before the amended law, the former regime said that it is not necessary to register a trade name in order to have it protected or to prevent third parties from using. But now the law, there is an article that was specifically drafted for it, order the registration of trade name under the law on intellectual property as a trademark in order to prevent the use of that trade name to third parties. So that concerns every company established in Laos since the very beginning. And this is why I think it's a very important one. In the amended law, I noticed that one article remained unchanged and still refer to the former regime, saying that trade names do not need to be registered in order to obtain protection. But I think it's just an oversight of the legislator, and it was confirmed by the DIP that actually registration is not just strongly recommended, actually, sorry for that, but is mandatory if you want to be protected. Another change is the fact that now the MYC, the Ministry of Industry and Commerce, can cancel trademark after their registration on 2 grounds. First of all, non-correctness and bad faith registration. Those 2 terms are not defined under Lao law. However, non-correctness, we can assume that it means if a trademark do not do not meet the requirements in the law for registration, or do not meet anymore the requirements for registration. And bad faith registration, and here I would like maybe to stress on this, it's a principle that is also commonly used even in other jurisdictions. It's basically, if I have to explain quickly, it's, if we take the instance of a trademark, it's when someone registers a trademark, but not with the intent to use it for unusual business purpose, but just maybe to annoy the competition. Here I took 4 instances, you can see. I took also the instance of cyber squatting, which is more about domain name, but basically you may have heard, especially maybe in the beginning on the internet, where many people used to register domain name with very famous brand, not to use it to sell product bearing that brand, but just to have an opportunity maybe to sell it to the legit trademark owner later on at a very high price. That's a bad faith registration. The same goes with brand blocking, for instance. If one wants to register a trademark just to prevent someone from entering the market. So here it's a bad faith registration, and the MYC has total discretion to actually consider if the cancellation is will be made or not. Now, talking about patent, petty patent, and industrial design. By the way, when you talk about patent, it's just invention, actually. So one of the key criteria for patent, petty patent, and industrial design is that at the time we file the application to register and to protect those with the DIP, it must be new. That's the novelty criteria. We could assess if the patent or the invention is new or not. If, for instance, if the invention was disclosed previously in exhibitions or in mass media magazines, then it would mean that the patent is not new. The novelty requirement is not met with. However, it was not clear if the disclosure could also be made through electronic means. So now the amended law clarified the fact that disclosure can also be made via electronic means on the internet, for instance, web page, social media, and so on. And so if the invention or the design was previously disclosed on the internet, then the novelty requirement may not be met and the registration will be rejected. Still about patent and industrial design, there is a new disclosure requirement according to the new law, amended law, sorry. For invention, for instance, at the time the applicant filed the application, now the law says that if the invention is derived directly from local genetic resource or local traditional know-how from some local community, for instance, then the applicant must indicate it in the application. That's interesting development, I think, and it goes with maybe the general policy of Laos, the government as a whole, to promote local community and minorities also as well of the country, and to make sure that there will be some kind of benefit sharing at some point if an invention becomes popular, for instance. The only maybe pitfall for now would be that there is no mechanism on how that sharing, benefit sharing will be made, actually. But we have the article, the law, then maybe the benefit sharing could be made through royalties and so on. That's something that would need to be agreed between the local community and the actual inventor, for instance. Now, talking a little bit about copyrights, there are some changes also as well. So here you can see the revised Article 91 of the law on intellectual property. So formally, the law provided a list that was exhaustive. So basically, if I wanted to know what is an artistic work under Lao intellectual property law, I would need to look at that article and see the list provided. Same thing goes with literary and scientific works. So those artistic work and scientific works were protected and still are protected under the law on intellectual property according to the copyright regime. What is new is now what you can see in yellow highlighted. Now we can see that the list is not that exhaustive anymore, and that the DIP gives itself some room maybe to consider other work other than the one in the list that we had before, that other works may fall under the scope of the protection of copyrights. For instance, here for artistic works, we can see other artworks. how in practice, what could be actually in play here? Some works sometimes are not very clear whether or not they would fall under copyrights and then would be protected. That's the case for, I would say, maybe for TV football game broadcasting. There is a lot of issues. I talk about football, but it could be about basketball and so on. So sometimes broadcasters wanted to protect these rights against piracy and invoke the copyrights. But as you can see, sometimes it was not very clear, actually. Sometimes it's not very clear that if whether or not those broadcasting would fall under artistic work and then would be protected by the law on intellectual property. Now, with that addition to the law, I think it's an interesting development, and that would give the DIP some room to consider if a work may be considered protected under copyright. Here, the consideration remains at the discretion of the DIP, so we have to be convincing if we want to prove the DIP that something is fall under the copyright regime. Also, as you may know, a copyright do not need to have registration to be protected. So as soon as you create something, a drawing, or for instance, or any type of artistic works here, then it's protected. Then the burden of proof would be to prove who was the first creator, for instance. But what was not clear is whether creation in electronic form would be also considered as protected by copyrights. Now the law clarified that by saying yes, electronic form, copyrights in electronic form, artistic work, sorry, in electronic form would be also protected under the copyrights regime. Also, now we can see an extension of the copyright protection for applied art and pictures from 25 years to 30 years. Finally, talking about the change of the amended law, the revisions, an interesting one because it clarified the scope of application of the law, is that the law has no intention to regulate personal use of intellectual property. So here the law will apply and prohibit the use of unauthorized use of intellectual properties made for commercial gain. So as soon as we generate some benefit, either a monetary benefit or any other type of benefit actually, without the consent of the owner, then we may fall under the scope of the law and be punished accordingly. But the law does not have any intention to interfere with personal use of unauthorized use of intellectual properties. So I think that is it for the amendment of the law of 2023. And moving on, I will be speaking about parallel import in the country. So here we'll be saying, is parallel import regulated in Laos? How is it regulated if so? And is it authorized? If authorized, are there any way maybe to mitigate the consequences of parallel import? So let's move on. So first of all, what is parallel import? So there is no definition in the law. You may have heard also of gray market imports. That's just a synonym. But basically, when we talk about parallel import, we talk about the purchase of genuine goods. So here we're not talking about counterfeit goods, something that would infringe any intellectual property. It's the purchase of genuine goods in a market. It could be an international market. From a Lao perspective, let's pretend that here we're talking about the Thai market. So it's the acquisition of goods, genuine goods, in the Thailand market, where prices are usually lower. And then the act to take those goods, go back to Laos and release those goods at the cheaper price than what at the price they usually sold in Laos. And all doing that all without the consent of the brand owner. So that's what we call parallel import or gray market imports. So why I'm talking about this today, because actually I didn't mention in the key development because I wanted to make a specific section on this, but the law on intellectual property now has introduced a new principle, which is called the exhaustion of rights. And you may have heard also maybe the first sale principle also as well. So what is it exactly? So here I will just say what how the law defines the exertion of rights. It is once wants the owner of industrial property rights. So when we talk about industrial property rights, it could be trademark, patents, design, or an authorized individual, let's say a licensee or franchisee. I release the product into a market like Thailand. And so actually they lose control over the distribution, importation, sale, usage, and transfer of those products. So basically it's to prevent the prohibition of reselling goods once someone purchased the good legally. I provide a diagram just below. So first we can see a factory producing shirts. Those shirts are released into a country A, could be Thailand, where the goods here are legally sold. Let's pretend it's sold to a Lao individual or a company who went to Thailand to buy those goods. Then those goods are taken to Laos and are released into the Lao marketplace. And here, actually, what the law means by exertion of rights is that the brand owner has no control over the right. They cannot prevent from an authorized dealer, for instance, from buying goods legally in a country and then taking those goods back to Laos to sell them. So that's a problem for many businesses in the country. I used to have the occasion to talk on this many times. And so what's the, so now the amended law actually consecrate that exertion of rights and kind of officialize the fact that parallel import may be authorized, at least at some point. So when we talk about parallel import, usually there are two sides, pros and cons. So the pros and would be more consumer based, and that's the stance taken by the Lao government even before the amended law. Actually, the parallel import was kind of tolerated. There was no question about it. And for those people who think that parallel import is good, is because it provides lower prices. There is more competition. So not just only exclusive distributor may sell some specific goods, but anybody will purchase the good legally. So lower price, greater viability, because maybe an authorized dealer or an authorized distributor may just focus on specific location of the country where the profitability would be high. And at the end of the day, it provides more higher purchasing power to the Lao citizen or people living in Laos. That's from a consumer perspective. And that's the perspective, I think, from the Lao government, as far as I know, as of today. And the amended law actually just tells it. But from the brand owner's perspective, that's not the same, because they will see that as a loss of brand control, because the brand owner may have an agreement with the exclusive distributor, but they don't have an agreement with an authorized distributor going to Thailand and then taking those goods to Laos for selling. So they cannot control how the product are actually maintained and so on. There is also the problem of free riding on marketing, meaning that those unauthorized importer will take benefits of all the marketing made probably by the local branch of the brand owner in Laos or made by the official distributor in Laos, while the unauthorized dealer, they would just sell the product and taking advantages of on the advertisement made on the product without actually dispersing anything. It reduces also incentive in terms of research and development. So the local branch of the brand owner or the authorized distributor will not want to invest more in terms of research and development, but even in terms of marketing, they will not want to invest more generally, do not want to have more employees, because they will not have the return on investment, because all the sale will be of the product will be shared among lots of different distributors. And then there is a brand reputation risk, because again, we do not know how those products are handled by the unauthorized dealer. So the problem is, I think Laos is particularly prone to that type of behavior, because as you can see, Laos is a landlocked country and has huge borders with Thailand, Myanmar, China, big one with Vietnam and Cambodia. So the country is very prone to those type of crossing of the border to go to a market where the goods will be cheaper usually before buying in and then going back to Laos to sell it, especially Vientiane. I don't know, but I think Laos is one of the few countries where the capital is at the very border, almost of the country. Here with Thailand and people living in Laos, you know, Udon Thani is not very far away, and you have those big department store and malls where people can go and purchase goods at a very low price before going back to Laos and selling those goods. That will not benefit to the actual local branch of the brand owner or the authorized dealer. There are some conflicting provisions, even though we have that new principle of the exhaustion of rights, because previously, and that's still the case, actually in the article 4850 of the amended IP law, usually the IP rights holder will have the power to prevent the use or even the selling or the advertisement of any product bearing their brand. But we can see that now with the exhaustion of rights principle, that's different. And these prohibition on preventing people from using a brand product bearing a specific brand may apply, but not at all time. But there are some limits to parallel import actually in the country. First of all, certain type of product cannot be brought into Laos by other people than other importer than the authorized importer. Here I raised some example vehicles, but if we talk about drugs, before we can import drugs into the country, into Laos, the drugs must be registered with the Food and Drug Departments in the Ministry of Health. Then there is a license provided to a specific importer, and only that importer will be able to import those drugs or medicine within the country. So if a third party wants to import, it will be blocked by the customs checkpoint. Also, literally at least, the exertion of rights does not seem to include the advertising of products, meaning that, again, when we read the law and literally, it will be good to see in practice how that will be interpreted. But in literally, it could be possible for a brand owner to prevent third party from making marketing on a specific product that was imported through a parallel import. And another thing as well is that the exhaustion of rights principle will not relieve an authorized importer from complying with local regulation, meaning that when they buy product in Thailand, most of the time, when you talk about food, for instance, most of the time the labeling will not be in Lao language, it will be in Thai language. Also, the labeling may not contain all that the law of Laos requires a labeling to contain. So this is where, again, maybe the brand owner or the authorized dealer can try to act against those unauthorized dealers. And indeed, an authorized dealer must also pay custom duties. So this is where maybe there are some action that can be taken. So here are some key acts maybe to mitigate, key action to mitigate parallel import in the country. Even though there is a lot of things, I guess it has to take into consideration some commercial aspect of it. But basically, especially in bordering regions like Udon Thani, one must be careful about the number of authorized distributor there is, just to make sure that they control how the goods are resold to other potential distributor that may go to Laos thereafter. Usually, a general advice also is regional pricing, making sure that there is not too much difference between Thailand and Laos, for instance, for some product that would be, because there will be less incentive for parallel importer to do so if the price is about the same. But again, I do understand here there is commercial aspect to take into consideration, and I know that for a fact that Laos is usually more expensive. Product differentiation, so maybe the packaging could be different for goods specifically for the Lao market and goods that are not, or maybe some additional service for product bought into the official channel. Track and trace, make sure that you know who is doing what in terms of parallel import, so that you can take legal enforcement action also as well if those do not comply with at least labeling, customs duties, and so on. That's why also working with the customs department is very interesting. But that's maybe more the work of a chamber of commerce like the EuroCham, making sure that all businesses speak in one voice and advocate the government maybe for take into consideration a more longer term approach, because on a short term basis, maybe the consumer based approach makes sense. But on the long term, is it the case? Maybe it will drag down the price, but then the price will be so low that even those unauthorized dealer will not make any benefit of it, and then the business will not be good. It will also not help in maintaining product in good condition and so on. So there are a lot of things actually to do about it, but the government lobbying is definitely a long-term approach. So now I would like to discuss about trademark. I think we have something like 15 to 20 minutes ahead. So trademark. First of all, and thanks a lot to the Department of Intellectual Property for providing me with those numbers. Some figures so that you can understand the importance of trademark in Laos when it comes to intellectual property. The filing of trademarks in blue, on the left side of your slide, in blue color, has been increasing all years long. And it's very interesting to see, and it means that the Lao marketplace is an appealing market for brand owners. And so you can see that that increase of trademark from 2022 to 2024. For the registration, it goes decreasing. It could be made because of maybe some internal restructuration also, and the workload that increased quite a lot. Let's see how things will go for the next year. But what is important, I think, maybe more important, is to see that the filing is still attracting a lot of people. And you can see in contrast those filing and registration for design over the years and invention like patent. So briefly, what is a trademark under Lao law? Make it short, it's any sign, combination of sign that allow the consumer to distinguish one product from another or one service from another company. And that can include name, logo, design, graphic representation, and so forth. Here are some examples of trademark registered in Laos. I've taken those examples from the Department of Intellectual Property website, which has a database, and also you can have a similar database in the WIPO website. They have a service called Global Database, where you can consult all the trademark register or which has been filed to the Lao Department of Intellectual Property. So you can see either it's a very easy design, green rectangle, Chinese character, names, or even the packaging here of a famous water company in Laos. All those things can be actually registered as a trademark and then be protected. Required documents, so pretty easy. An application form from the DIP that can be also downloaded in the website. If we have some time at the end, I will show you how the website works. Also, a specification of the mark, either it's a trade name or a logo or design, so an example of it. The description of the goods, services. So here, you have to understand that every time you want to register a mark, that mark must be associated with a class of goods or services. For instance, if I have a car company, then I will say that my mark is associated with cars or construction of cars or car selling, car rental, whatever. And so my goods or services will be protected according to the class I have registered the trademark with. But we'll get back to that in the next slide, actually, on the classes. And then you need also to have a POA, a power of attorney, if you use the service of an IP service provider. Finally, the proof of payment of the official fee, but just makes sense. Documents can be filed in English, but a translation will be required within 90 days. By the way, for the translation, it must be also certified by a translation company authorized in Laos. Classes. So, total there are 45 classes. 24 for goods and 10 for services. Here I took some example of classes that you can see: musical instrument, clothing, footwear. I took those examples from the WIPO website. I left the actual link in the slide, so feel free to request the slides at the end of the webinar so that you can also check yourself, and it's just very good information if you want to pursue the registration of a trademark, so you may understand better how that works. But one thing to consider also as well is that your product or the mark may actually concern product which fall into more than one category. For instance, at the very bottom of the slide, or almost, you can see that if you're a tour company, you may provide services about booking of seats for traveling, like airplane, air flight, and so on, but also for shows, theater, and so on. And so you have to understand that the classes may be different. And so you may want to consider filing a trademark application in more than one class if you want to be protected for the service provided in relation to booking of seats for traveling or shows. So that's something to take into consideration also as well. Again, the website I provide below are very useful source of information in that regard. So feel free to go and check. And if you have any question, let me know. For the registration procedure, so here we are talking about the national phase, not the Madrid protocol again. It's pretty straightforward. I say 10 to 12 months for the whole time frame. However, could depend. Sometimes it could be a little bit shorter, sometimes a little bit longer. But it starts with the filing of the application indeed. And then there is a formality examination. Here, the officer only checks if all the documents were correctly provided, if more information may be required also as well. If there is no comment from the officer, then we move on to the next stage, the first publication. So on the website of the DIP, and again, if we have time, I will show you how it works. On the website of the DIP, there is what we call the Industrial Property Official Gazette. And it shows time to time all those trademarks which are pending for registration. And so once the formality examination is done, 15 days after that, then there is a first publication, and that allows anybody, actually any third party, to oppose to the registration of a trademark. For instance, if I feel that one of the pending registration may infringe my own rights, or it's a trademark that looks similar or identical to my trademark, I may oppose to the registration of it. So I need to file argument to the DIP, Department of Intellectual Property, to oppose. And then the applicant will have to respond to that. And at the end of the day, the DIP will consider who is right, who is wrong. If there is no opposition, then the publication is open for 60 days. So there is 60 days. And after 60 days, if there is no opposition, no comment, then there is what we call a substantive examination. So here the DIP will be checking on whether or not the trademark comply with the requirements by law. It could be whether or not the trademark is a bad faith registration, or seems so, but also if the mark maybe infringed the public order principle also as well. So once that substantive examination is done, then we move on to the registration of the actual trademark, and the trademark certificate will be issued to the applicant. Usually the trademark certificate is not sent immediately once the mark is registered. And at the end of the day, you have the final publication, the second publication. Once the second publication is made, there is a period of 5 years from the date of the second publication for a party to request the cancellation of the mark, a third party. So there is still some chances for someone to ask for the cancellation of that mark. So this is basically how the registration procedure works in Laos. Scope of protection. So it gives you a protection for preventing third party from using your trademark for a period of 10 years that is renewable. And every time you will want to enforce your intellectual property rights, it will be necessary that you show the trademark certificate to the authorities. It's unlikely they will want to act without the trademark certificate, actually. One thing I wanted also to mention is that Laos is a first file system country, meaning that the first person to file and obtain the registration of a trademark, the registration certificate, will have a monopoly over the use of that trademark. So it's very important that you do actually register in the first place your trademark, even before, most of the time, before the services or the goods are released in the market. Also, the more original is your mark, the more chance you will have to have a smooth registration, because the mark will not be what we call descriptive or generic. For instance, if I have an ice cream company and I want to call my company Cold and Creamy, it's too descriptive. So it's unlikely. So I just actually describe the goods. So it's unlikely I would be able to register because the DIP will not want to prevent other people from using those words also as well, cold and creamy when we talk about ice cream. So usually your brand, your trademark must not be descriptive or generic. For instance, again, if I want to open a shop computer or computer company, I cannot call my company maybe, but I cannot have a trademark computer. It's not possible. I would not be able to actually prevent third parties from using the word computer if they're also a computer company. So that's how it works. So the more original your brand is, the more easier, I guess, the registration will be. And the more chance to protect it also you will have, because it will be easier probably to demonstrate that someone is really trying to copy your original design, logo, and so on, than something that would be more generic. Also, something to be very careful about, make sure that the trademark is registered at its use. So if at some point you change the logo, you must also make sure that you have registered the new logo of the DIP. Consider registering under multiple classes. We have already seen that. And registering the mark in the local language can be also helpful, because sometimes some maybe local business want to register the same brand but written in Lao language and saying that the characters are just different. It's not supposed to work. It's supposed to be an infringement also as well. But if you want just to make sure, you want also maybe to consider filing the registration application in local language as well. For imported product, one thing, if you're a foreign-based company, based in Europe, let's say, and you rely on the distributor in Laos, you want to make sure that the distributor will not be registering your mark under the distributor's name, because then you're losing all the rights over your own brand in Laos. So if you have an agreement, a distribution agreement also with them, make sure that there are some clauses saying that the distributor cannot register without your consent the trademark that they are actually distributing of the product they are distributing in the country. Research the local market to know if there is any fake, counterfeit, and take action if so. Conduct a trademark search that can be done with the DIP. So before you file a trademark registration, you may want to know if the mark is actually available or not. And then keep customs record all in mind. I didn't explain much the custom record all procedure, so if you have any question in the Q&A session, feel free to ask. So now briefly about patent. So patent, it's actually an invention. It's a certificate granted to the owner of an invention that is new, involves an innovative step, and is capable of industrial application. An invention that is a technical solution used to create a new product of process or production or to resolve a specific problem. So for instance, let's say we have a bottle. If you create some kind of handle to the bottle, that will not be something sophisticated enough to be considered as an invention. So it will not be actually accepted under the eligibility requirements. It will be rejected. So here we have to face with some invention of specific skills. So there are a number of inventions that may not be eligible for protection under Lao law. So as you can see here, it's all provided in the revised Article 21. Discovery derived from nature, encompassing living organism or their components. Scientific concept, theories, mathematical algorithm, or universal business or game regulation. These are not available for protection. Method for diagnosis, treatment, and surgical procedure applicable to human or animals, flora and fauna also. And invention that conflict with national culture, social, ethics, environmental standard, and so forth also as well. So those, whenever there is an invention that may derive from those components, it cannot be registered for protection. So here are all the documentation that is required in order to obtain, to be granted with a patent. So they are kind of, usually the volume of documents is pretty lengthy in most of the time. And here, that's the registration procedure. So all in all, registering or being granted with a patent is a lengthy process, 32 to 52 months. Most of the time, it could be longer, it could be shorter also as well. So this is why you have to consider maybe taking the fast track route as I mentioned before, that is available via the bilateral agreements. So again, recently in 2024, Laos has entered into a bilateral agreement with the European Patent Organization, meaning that once a patent is granted in Europe, then the patent can be used and filed with the DIP. The patent granted can be filed with the DIP so that the DIP may go through the registration process in a way faster manner, because there will not be all that type of substantive examination phase. And talking about this, just talking about the resources of the DIP in terms of patent, there is not the human resources yet available in Laos to proceed with all the examination. So most of the time, all the examination relating to invention, patent, will be conducted abroad, okay? Another thing I wanted to mention is that patent for pharmaceutical medicine is not yet viable in Laos. So this is why we cannot register be granted a patent for medicine. This is because these developed countries have been granted for some time before implementing this type of protection in the country. That will be available only in 2033. So again, as I said, Laos entered into several bilateral agreements, so please feel free to also check on this. Now, about the scope of protection, 20 years of protection for an invention. Again, invention owner can prevent people from using, importing, selling the patent. And again, whenever you want to take an action against someone that may infringe your patent rights or your invention, then you need to show the actual registration. And by the way, the protection starts the same with trademarks, start at the time of the filing. That's a very important thing to note. So you do not need maybe to request to wait for the whole time, even for trademark, the whole time to obtain the trademark certificate before taking action. Now about design, that would be the last last topic we'll be speaking about. So design is refer to the appearance or configuration of a manufactured item encompassing elements such as shape, pattern, line, and color. So it must be novel and made for decorative purpose. The ornamentation may not be some kind of a new function to the product. It may only be for decorative purpose. Sorry. So here's the documentation to file with the DIP. And here I provided some example of how usually, what type of picture you must make in order to file industrial design application with the DIP. So they will require that 7 different angles most of the time for 3D project, 3D object. Here you can see we're talking about the car, but it could be also the packaging. And sometimes even brands, they will, in addition to trademark, they will want maybe to register their packaging as a design in order to enhance the protection. That's the case specifically with car. In Laos, you may have seen motorcycle looking very similar to very famous motorcycle with a very famous brand. But the thing is, as soon as you take out the brand from the motorcycle, then it's not a trademark infringement anymore. So this is why you may want to consider also filing the registration for a design, because then you will be able to prevent third party from using similar design or identical design to yours. The procedure is rather short, 6 months. And again, it follows exactly the same, more or less the same thing as for trademarks. So there will be formality examination, publication, allowing third parties to actually oppose the registration before having a more substantive examination where we will make sure that the design does not infringe any type of requirements by law, and then proceed with the registration. Scope of protection, up to 15 years, not renewable. Same for patent, not renewable. Again, it gives the right for the industrial design owner to prevent third parties from making, importing, selling, or using the design, and facilitate the enforcement of IP rights, because you will not be able to take action, most likely, without a design patent granted. Comment. So again, you may want to register your design if it's a strong selling point, for instance. It helps to prevent the copying the look of a product, as I mentioned, just for instance, for design of motorcycle or even cars. And it will be, then you, even though the product does not bear your trademark, but the design is similar, then you will be able to take an action. In terms of official fees, it's pretty cheap. Here is official fees, meaning the fees from the government only, or from the DIP. These are not the fees that you may have to pay if you use a service provider. If you want a list of service provider, maybe EuroCham would be able to provide you a mini IP service registration company, IP service provider. There are some, a lot in the country, so you may be able to ask for a quote, for instance. And here are the key takeaways of everything that we've seen. So feel free to consult, but maybe I will, instead of just saying what is on the screen, maybe we can start the Q&A session if there is any question. Stefano?
Yes, thank you. Thank you, Dino, for your very comprehensive presentation today. We have some questions. So the first one, what do you reckon to be, in your opinion, the best approach for a company to address parallel imports in Laos?
So it depends on what product we are talking about. What would be the best approach to prevent parallel imports, right, Stefano?
Yeah, to tackle the issue of parallel imports when some countries, some companies have to face.
So here we're not talking about fake goods entering the country, right? But genuine goods, parallel imports.
Correct.
Okay. So actually it will depend the type of product we're talking about. If we're talking about restricted goods, like I say, drugs and cars, for instance, that will be pretty easy. At least there will be a little bit of investigation about who is importing those products or those goods as a gray market imports. And then we may take action because it's pretty clear that an authorized party an authorized importer cannot import those goods. Now, if we are talking about goods that are not restricted, most of the daily consumption goods, for instance, like shirts or so on, or even some food product, it's more difficult. And I would say, even before the amendment of the law, the government had a very tolerant approach in that regard. And they were saying that it benefits our consumers because it dragged down the prices in the country. Now, that said, what we realized also as well when I used to actually tackle those issues is that those parallel importers were not very compliant with our law, either in customs duties, for instance, or labeling requirement, language requirement on the packaging. So even though you may not be able to prohibit, because the law definitely says it's fine because of the exertion of rights principle, the brand owner cannot prohibit the resale of those products that were purchased legally elsewhere. But maybe you can annoy a little bit those unauthorized importers, making things more expensive for them to actually proceed with parallel import, either making sure that they are paying the customs duties actually, or making sure that they do fulfill the labeling requirements issue also as well. But other than that, it may be difficult. You may also see if they are doing advertising. As I said, the law does not seem to include advertising for the exertion of rights principle, meaning that if an unauthorized importer actually advertised about the type of product they have imported in the gray market in Laos, by law, literally speaking, at least, it could be that the brand owner or the authorized dealer may be able to prevent the advertisement of these products that were not imported through the official channel. It's pretty difficult otherwise.
All right, thank you. Let's move to the next one. What is the maximum number of classes a trademark can be registered with?
What is the maximum number of
classes?
There is no number, as far as I recall. There is no specific number limit to this. But one thing is that, and maybe I can show you a little bit the website then. Do you see my screen or not anymore?
No, now we see you.
You see me only, right?
Yes, correct. Okay,
wait. I will try to see if I can show you a little bit the website I was mentioning in my slides. So here, I think, yes, okay. So let me share with you my screen again. Yes, share. Do you see it?
Yes, we can see.
So here you see it's a WIPO, so World Intellectual Property Office. So they have a very informative website about each class, what they may contain and not contain. The thing is, you have to make sure that the class you want to register your mark with is really associated to that category of class. One thing that can be, otherwise, some people may request the cancellation of your registration, at least for certain class, if you do not use the brand for that type of class. So this is why you cannot, for instance, register your mark, your brand in 45 classes. I mean, it doesn't make sense, I think, unless you propose all types of services and all types of goods relating to that brand. Because at some point, people may also request the cancellation of, at least for some classes of your brand, because they may want to use the same brand or a similar brand and you're not using it. So that's something also I didn't mention in my presentation, but people registering a brand, they have a duty to use that brand. If there is a proof that you're not using the brand in that particular class for at least 5 years, then third party may request the cancellation of at least part of the registration in terms of class. So there is no limit to how many classes you can register, but think about it, it will be more expensive also as well when you want to register more than one class. So you may not want to register in too many classes, and moreover, I do believe that if you register in all the classes, you may not be actually using your brand for all those type of goods. So here, that website, is very interesting because you see class 2, for instance, it will say exactly what it may include, class 2, but they will also include, they also will explain that this class includes in particular, and then there will be some example. And if you're not sure if actually what you want to register on the class, you should be registering also as well. They also say that that class does not include in particular those type of goods as well, and they will refer you to the correct class. So I think that's a very useful website to have in mind. And I just ask for the audience to have a deeper look maybe in that website if they want to have more information. But just to respond briefly to the question, there is no limit to the number of classes you can register.
Thank you, quite clear. And the next one is, how many trademark registrations and design protections are roughly registered in Laos? Do you have an idea?
Do you see my screen still?
Yeah.
Okay. So I think I gave some numbers here. So for filing for trademark in 2024, we talk about 4,191 registrations application that were filed actually with the DAP. When we talk about design, it was 32, and invention, patent, it was 49. So that's the number. And this is why I was saying that trademarks is by far the most filed and registered intellectual property in Laos, which also is also the case in other countries, but at another level. I mean, here there is no, patent is very, I would say, very rare in comparison to the numbers of trademark.
Okay, we have one more question from the audience. Does the Department of Intellectual Property also give advice to companies that are seeking to learn more about IP and how to register their IP?
Yes, they do have some kind of a one-stop service at the Department of Intellectual Property. The Department of Intellectual Property, so you do have the Department of Industry and Commerce also as well that propose that type of service. So they do provide some service against an official fee. I think it's very low fee, maybe 50,000 kip or something like that. So they can provide some advice on the procedure and step. The thing they will not do, however, is they will not tell you the changes you have to register your mark. They will not want to kind of endorse whether or not your mark will be registered smoothly and without any issue. Also, one thing that the Department of Intellectual Property can do is that if you walk in the street and you see maybe some products bearing a trademark that is similar or identical to yours, you can have some kind of collecting information about it, and then ask the DIP if they believe that it's an infringement or not. So that can be useful, because then once you have the opinion of the DIP in that regard, you can take action, like we call administrative action. Either you may first start with sending a cease and desist letter to the infringer, saying that we have proved that you are infringing and blah, blah, blah. If they don't stop, then you can maybe go further and request even for the seizing of the infringing goods and the destruction of it. I mean, basically that's the thing you can do. But it's very interesting to see that the DIP is also proposing that type, offering that type of service also as well.
Thank you. We have another question for you, Dino. How can trademark registration in Laos be important for a brand protection strategy in the ASEAN region?
Okay. So, so here you still see my screen.
We still see the WIPO website.
Oh, so here, you just see the web website? Oh,
yep.
Sorry. Okay, so just before you didn't see what I actually was sharing. So wait, I will be. Okay, so now you may be seeing my slides, right?
Correct.
Okay, so just to get back a little bit earlier, because you may not have seen it, that's the numbers of filing and registration of trademark and design. And you can see the number for trademark is very important. The numbers for design are not that important, or patent also, as compared to trademark. So when we talk about registration of trademark, we talk about 4,991 for the filing, at least. When we talk about design, it's 32, and patents, 49. Now, getting back to why is it important? Laos is important because, for me, as I said, whenever you have sometimes big brands also as well, they want to protect their brand in the ASEAN market. And many times Laos may be overlooked because it's not a very important market. Let's face it, but for now at least, as compared to Thailand or Vietnam, even Cambodia is very dynamic now. But I think that's the location of Laos that makes Laos a very important tool for a brand protection strategy, because if you register your trademark in the country, you may prevent the transiting of infringing goods that goes from, for instance, Vietnam to Thailand. So you may be able, of course, against some intelligence and information that you may have, that a good a shipment containing infringing goods may be crossing the border and coming into Laos, or transiting only. You may be able to stop infringing goods crossing Laos only. So Laos may not be many times the final destination market, but will be definitely a country where lots of goods are transiting before reaching the final destination. So that is why, for me, Laos is a very strategic place. And here we don't see it, but there is China at the very top of the map. And so lots of goods are crossing the border from China to Laos before reaching maybe the Thailandese market. So again, this is why, for me, Laos is very strategic. If you do not register your trademark in Laos, you cannot take action against those shipments crossing the country, basically. So Laos should be a very important strategic place in relation to fighting counterfeits, I think.
All right, thank you. This was the last question for today. We are 20 minutes past 10, and I believe we can conclude our webinar here. Therefore, I would like to thank you all for joining us today. We hope that you found the webinar valuable and useful. And of course, please feel free to reach out to EuroCham for any further assistance you might need. I hope you have a great weekend ahead, and see you next time. Thank you.
Bye-bye.